Okay, welcome back. So as I stated, I'm going to introduce, in addition to my great guest, Gene Rossi, we're always on together. Every now and again, I have a chance to be on with Judge Brandon Birmingham. You guys know him well here at the Law and Crime Network. He is a top judge out there in Texas. And what was always the most impressive thing to me with of all of his massive credentials is, Judge, if I got this wrong, let me know, that the bench does not belong to you. It belongs to the people, the sign that you have facing you every day you go out in a court. Welcome, Judge.
Well, thank you very much. You always give the best introductions, man. It's very good to see you.
Well, it's easy with guys like you. So, Judge, let me talk a little bit about that last clip first, okay? Now, I'm not sure because I was having a little difficult time hearing the audio, but through the interviewing process, and of course, as you know, as law enforcement guys, as prosecutors and investigators, we want to keep the guy talking for as long as we can without them asserting their right to remain silent, hopefully. We advise them certainly of those things, but we want to make them comfortable, calm, and I've seen cases where they've done great for the first 2 hours and then just go down a precipitous slide. But in this particular case, it was pointed out by one of the officers very astutely that the defendant, I'm not sure if it was this clip, but clearly in the interview started using the past tense when he was referring to the victim in the case. And at that point, it was only a missing persons case. I think that that's one of those common sense little things. In addition, when you add the cell phone data, if in fact they proved that it was hitting off cell phone towers near where the bodies were found, that could be major clinchers. Little things, major differences in the case. What are your thoughts, Judge?
I agree 100%. When you're putting together these cases, and this is a circumstantial evidence case, this is a cold case, it's really going to be hard for the prosecutor to point at one thing in particular and say, see, this proves beyond a reasonable doubt that the man is guilty. You put things together, and all of a sudden, little insignificant statements like talking about somebody in the past tense, when considered in the context of all the other circumstantial evidence, the cell towers, the motive that he had, when he was using the QuickBooks and things like that, man, that statement could be very, very important. And you never know which little piece of the puzzle the jurors are going to latch onto as proof in their mind to solidify that conviction. Yeah, excellent point. And Gene, would you agree with me and the judge that when you're using the past tense, what I felt was really powerful was that the detective was smart enough to catch it, but then let him do it a number of times and then confronted him about it, and he kind of did a humana. I mean, that to me was even the icing on the cake.
And that's why I spoke about this earlier. It would have been great if we had a video of his humma and his pregnant pauses when she confronted him. But I agree with you and the judge that the past tense, even after he was confronted on it, he couldn't get over that Freudian slip because he knew, this is the government's argument, he knew in his mind that they're never going to be found.
Yeah, listen, hey, guys, we're hearing that the lawyers apparently were having some major arguments when they were not in court, but now they're having perhaps the same argument now in front of the judge. Let's check it out and see what's going on. Okay, welcome back. We're getting ready to start back in court again. There was a major argument that occurred between the lawyers where the prosecution's trying to call a detective to talk about bank records. The defense argued that they weren't qualified to testify about that. The judge ruled that they could show whatever records they want as an exhibit and highlight what they want to show inside that exhibit. That is the prosecutors. The exhibit speaks for itself. So we'll see how that's going to unfold once that starts. Let's go back to one more clip with Chase. I got my two great guests with us. Case is going. Great case. Let's listen to Chase. See if you can listen to him talking about past tense here.
Called myself, and I was dying. You know, that's what gave me a heart attack, actually. It was because we got really busy last year, and we were just cranking. Where's Dan? Dan was the one. He actually, to the best of my knowledge, he owns part of Earth Inspired Products. Joseph was buying him off. Him and Joseph kind of had they weren't real happy together. Or Joseph wasn't real happy having to pay him so much. Do you know what he paid? I have no clue. I have no clue. Joseph didn't tell me a whole lot about it.
And you, Joe, and Dan all lived in the same apartment at one time at the beach? Did you?
Oh, no, I've never met Dan.
Oh, you've never met him?
No, I've never met Dan. The first time I talked to Dan was a week ago or a little less, or when all of this started. Dan called me and said, "Hey, dude, what are we going to do?" I said, "I don't know. I don't have any access to, Joseph's emails. I don't have any access to any of this. I can't help him." And so Dan said, "Well, I can send you any pertinent emails if you can follow up with them. Any complaints, any problems with customers, can you try to deal with them so that when Joseph comes back, at least we've made an effort to, get this stuff taken care of."
What date was that?
Okay. That's the extent that I know about Dan. As far as my role, I met Joseph. He actually contacted me to start building custom waterfalls 2.5, 3 years ago. And I started building his custom waterfalls, and I'm still doing it now today. And so I don't have really anything to do with earth-inspired products. I have my own. I manufacture waterfalls. I had my own line of waterfalls, my own, everything. Joseph got me more deeply into the custom ones, and he does all the sales. Basically, we're partners in getting waterfalls done, and we make money, but.
All right, just to give you a quick update of what's going on in court, the witness is not testifying. What's happening right now is that those bank records are being shown to the jury. It's a little bit of an arduous and tedious process. So while we have an opportunity, while that is going on, I have an opportunity to speak to our great guest. Gene, again, these bank records, we just listened to a clip about the relationship. We know this is all going towards the prosecution of motive in this case. One of the arguments raised by the defense is a brutal murder. 4 people are taken out, sledgehammering. It's beyond just the average business dispute. Do you think from a standpoint of common sense that makes sense to a jury, that even if there was this business motive and he was angry, that it wouldn't go to this extent?
Absolutely. And I don't think there's any dispute that at some point in time, the defendant and Joseph McStay were very close. And the government wants this leap that, okay, they were close, but Joseph owed money to Chase of less than $200,000. Therefore, Chase is going to brutally kill 4 people. I mean, that's something that Ted Bundy would do. So if I'm the defense, I'm going to say that's an incredible leap.
Judge, it's great to have your expertise here, because Gene and myself have only been advocates. But there was a ruling made by the judge with regard to third-party guilt of Dan Kavanaugh, i.e. the defense wants to make an argument that he, too, there was a money issue between them, and there were some really salty text conversations that were going back and forth between them. The judge ruled that a substantial portion of what the defense wanted to get out would be inadmissible. I'm just curious as a judge, it would be my temperament if I were ever to be put in that position, that I would give the defense wide latitude in order to say another party, the wrong party, in other words, the state picked the wrong party here, may be responsible for this. What are your thoughts?
The way that I always look at that stuff is to just try to say, is it something that is going to be relevant, to move the ball forward one way or the other, to rebut one of the prosecution's theories or to put up an alternate theory? I tend to agree with you, and I tend to let stuff in as opposed to keep them out, and I think the rules contemplate that. I also think that lawyers would be wise to say, okay, I'm going to try to get it in now, and if the judge says no, well, that doesn't mean it's always not going to be admissible. Certainly things come up in rebuttal, and I'm always looking for that too. Judges don't want to get reversed for the family's sake. They only want to have a case tried once, both for the defendant and for the victim's family. So, it could be a deal where maybe it's inadmissible today, but tomorrow some door may be open, some other theory may come up, and you've always got to be watching. So I always tell the lawyers, make sure not to rest until you give me everything that you want to try to give me, and then I'll make a decision from there.
Excellent point, Judge. In fact, Gene Rossi and myself were indicating that some things that occurred today may very well have opened that door to reinitiate the conversation with the court to admit the Dan Kavanaugh testimony. Thank you, guys. You're awesome. I love having you as guests on my show. There's a witness on the stand in court. Let's go inside. Okay, so we're listening to testimony from the medical examiner, Gene Rossi, getting to the point that we had talked about earlier, the building blocks of a prosecution case. There always has to be medical testimony about cause and manner of death. It is essential to any homicide case. What are your thoughts so far about this testimony?
Oh, emotionally, Bob, this testimony is devastating.
Mm-hmm.
And this is the problem for a defendant in a case involving multiple murders, and you've been accused of multiple murders. When the jury sees the bones, the crushed skull, the scene where the bodies were placed, jurors are told to put aside bias, prejudice, sympathy, and empathy, but it's almost impossible to put those emotions aside because they want to find somebody who did it.
Yeah, and Gene, to add emphasis to the exclamation point that you just brought out there viscerally with the jury is when you're talking about children, and especially when you're talking about young children and the manner in which these children were killed. So when she's talking about the blunt force trauma and the fractured skulls, of course, keep in mind that there's a sledgehammer buried in one of the pits along with these folks. I think it even brings even more drama to the case. And you tell the jury, like you said, no bias, passion, sympathy, or prejudice, but it's really hard. When you take a look at that picture right there with that skull just smashed to bits.
Oh, it breaks your heart, breaks your heart.
Yeah, so, Gene, as you know, many jurisdictions are different. Some judges will limit the amount of testimony that the prosecutors will be able to bring out, but if it has relevance to the cause or manner of death, it's pretty hard to exclude it, but then they don't want to overemphasize it because it could lead to reversible error in some states. I'd say the more northeastern states. You got to watch how you play that as a prosecutor.
Yes, and I think we had a trial a couple of weeks ago or a month ago where the government wanted to put in, I'm picking a number, they wanted to put in 60 photos of the murder scene. And the judge said, no, I'll allow you to have 5 to 10. You can't have an avalanche of exhibits. But You're right. Premeditation, this is classic evidence that shows premeditation.
Right, especially where the mechanism of death is the skulls repeatedly over and over again. Gene, that is a really good point. It gets back to the same point we make over and over again as a prosecutor. Just because you can doesn't mean you should, because it's to protect the conviction as well. We got to go to a break. We'll be right back. Okay, welcome back as we're covering the McStay family murder case. They've gone on a short break, which gives us plenty of opportunity on this Law&Crime network. As you know, gavel to gavel coverage, Dan Abrams production. No one does it like we do here 24/7. We also have our very own Kathy Russin, who's been following this trial intimately and is always feeding information back to the hosts and the producers of the show. And she was actually in the desert, the area where these bodies were eventually recovered years later by a motorcyclist who was going by and noticed skeletal remains, particularly a skull. So let's take a look at Kathy's assessment of that scene, because it's really dramatic that this was the final resting place for the McStay family.
We are currently at the site where the remains of that family of 4 was found at the end of 2013, nearly 3.5 years after the family went missing. A motorcyclist came across the skull here, and investigators eventually found 2 shallow graves with the remains of the family. Now, this location is just north of Victorville, California, in San Bernardino County. Prosecutors say Charles Merritt killed the McStay family in their home in San Diego County and eventually drove the bodies here and buried them. It was a 3-pound sledgehammer. The cause of death is said to be blunt force trauma to the heads of this family of 4. The prosecutors in their opening statements say that Charles Merritt drove them here and that you can see a set of tire tracks. Now, it's very hard to see them now because so much time has gone by. I can actually see a little bit of them, but they were very clear, but even back 3.5 years after the family went missing. There's another set of tire tracks about 20 feet over. There are 2 actual grave sites. This is a memorial that the family put up, but just to the bottom of this is where the first grave was. The second one was about 20 to 25 feet over there. Now, the defense in their opening statements say that more evidence points to a third business partner, Dan Kavanaugh. They also say that evidence here at this scene show that there were more than one person that committed this. They told jurors they will see the 2 sets of tire tracks and they will see that they're not consistent with the same vehicle. They also put the theory up that Joseph McStay was killed, brought here, and that Summer and the boys were brought here alive and then killed here. They say that the family was not killed at their home. There is no evidence of any blood or any DNA found at the home to show the family was killed there. The trial is expected to last up to 6 months, and Charles Merritt will face the possibility of the death sentence if he's convicted. I'm Kathy Russin for Law and Crime.
All right, excellent reporting, Kathy. So, you know, Gene, we talked about this before. In this particular case, given the gravity of the victims, multiple victims, and 2 little beautiful children, one can't help but think of the impact not only of the medical examiner who we just heard testifying before they took a break, but looking at pictures like we see on the screen right here with the skeletal remains of that family, their resting place, if you will, has got to be extraordinarily powerful before the jury. But the question is, who did it? Did the cops get the right person?
And that's where the rubber meets the road. I got to say, this medical examiner, I think I heard her correctly. She said she does 400 to 500 autopsies a year. That is amazing. And how she is able to present evidence without, getting burned out is beyond me. But going back to what you just said, this case really is, it's got good arguments on both sides. It really does. And we got about 5 more months of it. 5 more months.
Yeah, and like you said, I mean, the fascinating part about this case is it does have great arguments that cut in so many different ways. Like, for example, we talked earlier about using the past tense, the defendant, when they thought it was just a missing persons case, and the fact that the cell phone tower, supposedly his phone is pinging off it in the area by the desert. But then you have so many other weird things where the cops initially thought that they had it locked and loaded, that this was actually the family leaving and going to Mexico, and that the truck was not Merritt's, but rather the family's vehicle. And you have all this, you have this Dan, Kavanaugh scenario where he potentially had a motive to be involved in this, and others that I'm understanding may potentially have had a motive here. And then they wait a year, even after the body, the bones, the skeletal remains are found, they wait a year until they arrest Charles Merritt. These are all areas that the defense is arguing. So it's really a razor-thin case here, Gene. If you had to call it right now, has the state gotten itself to a place where they've proven beyond a reasonable doubt to 12 people that it's Charles Merritt that did this?
I think it's close. The one piece of evidence that really troubles me if I'm the defendant is the pinging. His cell phone was at the grave site. There's no explanation. Nobody stole your phone. And if it did ping by the site, that's that big elephant in the room fact that's very hard to argue against. That one would bother me a lot.
Yeah, that is obviously a significant piece of data, and I've always liked that piece of data because it's objective. It doesn't take interpretation unless people actually falsify the information, which is virtually impossible not to be detected. But then again, Gene, I'll play devil's advocate here for a second. Let's assume that the bad guy may have either done something with the phone, or let's assume that he may be an after-the-fact witness that is Merritt, as opposed to the person who actually committed the murder. Possibility?
Yes, and here's the thing. I'm going to throw it out there. Kathy had a great point that there appears to be 2 vehicles. Okay, you assume there's one person in each vehicle. Maybe there were 2 people in each vehicle. You could have 4 or 5 people tragically killing 4 individuals, including 2 small children. it's a classic conspiracy. I'm going to throw something out there. How do we know that Dan Kavanaugh wasn't conspiring with Merritt? How do we know that? How do we know that?
Right, and how do we know that maybe Merritt was called up afterwards or for whatever reason was trying to help somebody else? I mean, this has happened. I mean, I have actually had cases, a number of them, where an individual helps after the fact and they're initially perceived, Gene, as having been at the scene, but it wasn't until afterwards that they actually helped dispose of the body. Gene Rossi, this is why we love having you on, my friend. Hashtag 4041. I know you have to go. You've been a long day here with Jesse and myself. I greatly appreciate it. Hopefully I'll see you later in the week. Folks, the McStay family murder case is still going on. We're going to take a quick break. We'll be right back.